Time to get our, I think it's our final session of the afternoon underway. My name is Chester Brown and I'm Professor of International Law and International Arbitration here at Sydney Law School. And it's a great honour to be chairing this final session of the day. And our title is Private, Commercial and International Investment Law. We have 3 speakers and 2 commentators, so a real smorgasbord of delights for you to round off what's been a fascinating day. I'll introduce our speakers briefly now. I'll do them all now so I don't have to keep jumping up and down because we have so many of them. We're going to begin with a presentation by Maureen Clark of the Department of Foreign Affairs and Trade. Maureen is Assistant Director in the Investment Section of the Regional Trade Division of DFAT in Canberra. And Maureen's task at the moment is that she's leading Australia's current review of Australia's bilateral investment treaties, which is obviously a big topic and one that's been in the news quite a lot in recent years. Secondly, we're going to hear from the University of Sydney's own Professor Vivienne. Vivienne, as many of you will know, is the Professor of Chinese and International Business Law here at Sydney Law School, and she's also the Director of the Centre for Asian and Pacific Law at the University of Sydney, and her teaching and research interests are in international business and economic law, private international law and Chinese law. And Vivienne is going to be speaking today about some recent decisions of the Australian courts concerning the enforcement of ICSID awards and the interrelationship between Australia's obligations under the ICSID Convention and state immunity. So some interesting interaction between Australian legislation as well as international conventions there. Then our third speaker, you cannot yet see, no, you can see our third speaker, Stacie Strong, who is also a wonderful colleague of Sydney Law School who joined us relatively recently, but it's wonderful to have her here, albeit she is sitting in Cronulla, not here with us in Camperdown at the moment. Maybe she's going to the beach later or been to the beach already, but you wouldn't blame her for doing that. Stacie is an associate professor here and specialises in private international law, international arbitration, international mediation and comparative law. She's taught at law schools around the world, has acted as a dual qualified English and American practitioner with major law firms in the UK and the US. And she also acts as arbitrator, mediator and expert in commercial, IP and trust related matters in domestic and the international spheres. And Stacie is going to be speaking to us about the topic of her recently published book, which is on judicial and arbitral decision making. Then we have 2 commentators, both also colleagues from the University of Sydney, Professor Luke Nottage and also Associate Professor Jeanne Huang. As you will all know them very well from previous iterations of the Sydney Centre for International Law Year in Review Conference. Luke is the Professor of Comparative and Transnational Business Law here at Sydney Law School and is the Associate Director of CAPLIS, the Centre for Asian Pacific Law at the University of Sydney. And Jeanne is Associate Professor here and she's widely known for her research on legal issues in digital trade and e-commerce, international investment and Chinese law. And they will be commenting on the presentations from our 3 speakers. Now, our 3 speakers have around sort of 15 to 18 or so minutes each, and our commentators have 10 minutes and we'll have some time for Q&A. And I've arranged for a Zoom glitch to be introduced if anybody oversteps the mark in terms of their allocated time for speaking. Without any further ado, I will hand.
Just the flicker. Oh, we're doing arrows, are we? Okay. Well, I think Maureen's presentation fits in pretty well to what I'm going to talk about. Now that she has helped to establish the state liabilities, I'll talk about the enforcement of those liabilities and how it's possible. Now, sovereign immunity, of course, is something with which I'm sure you're all more or less familiar. But basically, the sovereign immunity runs along the theory that a state is immune from jurisdiction and execution unless it's not. Now, in some cases, particularly China, there are virtually no exceptions to that general proposition because they subscribe to the theory of absolute sovereign immunity. Most other states have a restricted theory. to some extent based on a UN convention which was drafted and is very influential, although it never came into effect. And in the case of common law and other countries, generally based on domestic legislation. Now, this domestic legislation has a lot of similarities with other domestic legislation, but unfortunately, it is not the same. And so what this means is that you have a lot of cases where states are sued for various reasons, and then we have a long progression of appeals while the state argues that, in fact, it is entitled to enjoy sovereign immunity. Now, in the context of BITS and commercial arbitration, we have a number of actually quite high-level cases. They go up a long way. Garuda Airlines has been particularly helpful, I have to say, in terms of elaborating on various provisions in our own state immunities legislation. And I think it's likely that we are actually going to have many more cases. So although I'm going to sort of touch on some recent litigation in Australia and in other places, I'd like to first put this in some sort of context in terms of the sorts of cases that are coming through. So I'm looking here at ISDS investor state arbitration on the whole, and on commercial arbitrations which involve states, although of course, as we're all aware, sovereign immunity is also relevant in, for example, the recent cases of Taylor and the Attorney General, where someone was trying to sue Aung San Suu Kyi, human rights cases, a lot of employment cases. It's amazing how many employment cases relating to consulates and embassies there are in Australia. And I'm not talking about those. I'm talking here essentially about commercial arbitration, which actually involves states. But if we look at them in some sort of context, and I hope you can read that. I'll start with Spain, which is not a random example. Now, Spain has 52 investor-state dispute settlement cases against it. It is also the host state for another 59 cases, incredibly, mainly involving Latin American states. The ones against it generally involve changes to its energy policies. What's that? Sorry, host state for another 59. There is a whole series of litigations going on in relation to other disputes around the place. The one I've mentioned here was a series of arbitrations against the Congo, the Democratic Republic of Congo, which started out being for about $34 million. And by the time they got to Hong Kong 15 years later, were worth $125 million, but in which there were cases in Hong Kong, Jersey, the UK, South Africa, Australia, US, and all sorts of other places. So these can be really quite major cases. And given the vast increase in investor-state disputes, which have been recorded by UNCITRAL and generally being brought around the place, we can expect that there will be more of these cases. When the ICSID Convention was signed, apparently the theory was that states would just pay. There wouldn't be any dispute about payment. But as we can see from some of these disputes, particularly one which I'll touch upon, which involves Nigeria, the award in that case was for $6.5 billion for a natural gas plant that was never built and is now in excess of $9 billion. So it's no wonder that Nigeria is fighting that case vigorously in quite a number of courts around the world. The second aspect that deals with the likely increase in cases relating to sovereign immunity is the rise in sovereign debt. So there are various, of course, debt relief projects, mainly led by the World Bank and the IBA. But if you look at, for example, the HIDCs, the highly indebted developing countries, one of the issues in relation to dealing with their debt is commercial litigation. So although states may agree to waive or to reduce the debts which are owed to them, and the same with the international development banks, this in fact gives an opportunity for your enterprising vulture fund or hedge fund to jump in there and actually bring cases against these states on a commercial basis. And so again, this is going to be another area in which we have the sovereign immunity cases coming up. This is, to my mind, contributed to by the fact that international agencies are very heavily pushing the role of private finance in terms of infrastructure and other developments around the world. The view is there's not enough public money to finance all of the infrastructure and other major projects that need to be built. And if you look at their documentation, which I've had occasion to do over the last couple of months, this always includes recommendations that the states in question give guarantees, and that they be asked in that regard to give very comprehensive waivers of their sovereign immunity. So as an overall issue, I think this is going to increase rather than to be reduced. Now, looking at the Australian context, what sort of issues do we have? Well, the case which I'm going to look at to start with actually involves Spain. And what it relates to is one of the early batches of awards against Spain in respect of their changes in energy policies. And that's what most of the 52 cases, in fact, against Spain relate to. Now, this is a beginning one. It relates to in excess of 100 million euros, which is, you will agree, I think, an amount that's worth arguing about, particularly if you've got another 50 states, potential investors lined up trying to get similar amounts. And so the argument in this case relates to the enforcement of an award which is made under the ICSID Convention. That's the Convention for the Settlement of International Investment Disputes. ICSID is based in Washington. And when you sign up to the ICSID Convention, you would think, at least I think anyone would logically think, that as a state, when you sign up not just to obey the terms of the convention, and to engage in investor-state dispute, but you probably also sign up to actually pay any award which is granted against you. And that's what the argument in this case is about. Do states, in fact, automatically, by having signed the ICSID Convention, waive their immunity from jurisdiction of the courts? Spain was trying to argue in this case that, in fact, they did not. They followed in this respect an earlier case in 2017 brought against the Democratic Republic of Congo, that well-known defendant state. And essentially what their argument is that they did not automatically waive jurisdiction by signing the ICSID Convention, that in fact you have to look at the Immunities Act, and the Immunities Act provides that there's state immunity unless you give consent, or unless there's a commercial transaction, which we're not talking about. So, said the court at first instance, well, Spain did, by becoming a party to the ICSID Convention, submit to the jurisdiction of the designated court, which was the federal court, and it did therefore, because it had signed the ICSID Convention, waive immunity from jurisdiction pursuant to Section 10 of the Foreign Immunities Act. And therefore, said the judge, the question of immunity really only arises at the stage of execution. So I should say here that it's a sort of a two-stage thing in terms of sovereign immunities. The first is the question of whether as a state you're subject to the jurisdiction of the courts at all. If you can establish you're not subject to the jurisdiction of the courts at all, then essentially you're out. Nobody can pursue you from that point. But even if you are subject to the jurisdiction of the court, you can then try to show that you should be immune from execution over your assets. And in fact, that ended up being what the case of Nauru, Firebird and Nauru was about. Because in that particular case, the Vulture Fund had managed to get a Japanese judgment against Nauru in relation to some bonds of a government agency, which the government of Nauru had foolishly, as it turned out, guaranteed. Now, Nauru argued that they had sovereign immunity, which they failed on, but they did succeed in persuading the High Court that the bank accounts of Nauru, which were held in Australia, were in fact not subject to execution because they were used by the state for its own sovereign purposes and not for commercial purposes. Now, in this particular case, what Spain was trying to do was to shortcut this process essentially by saying, well, in fact, we're not subject to the jurisdiction of Australian courts at all. Now, how would they argue this? Because common sense would suggest that it's not a very good argument, but of course, common sense is not necessarily a particularly good indicator in terms of international treaties. I won't, and I'll try and explain the argument which they brought before the court, and which has taken up a lot of judicial time. It's such a bonanza for lawyers, this particular case. And Chester was hoping for a High Court decision, which is really, really fairly irresponsible, I think. And what it comes to here is that if you look at Article 54, it says that a contracting state has to recognise an award rendered pursuant to the convention as binding and enforce the pecuniary obligations imposed by that award within its territories as if it were a final judgment of the court, which seems to be pretty clear. Then in paragraph 2, it says that a party seeking recognition or enforcement in the territories of a contracting state shall furnish to a competent court a copy of the award, sort of certified by the Secretary General of ICSID. But then it goes on to say, this is the English version, that execution of the award shall be governed by the laws concerning the execution of judgments in force in the state in whose territories such execution is sought. And in Article 55, it says that nothing in Article 54 shall be construed as derogating from the law in force in any contracting state relating to immunity of that state or of any foreign state from execution. So what Spain was arguing was that in fact execution and enforcement are the same thing, and they had support for that argument in the French and Spanish language versions. Therefore, they said that because execution and enforcement are the same, this means that Article 55, which says that nothing in 54 shall be construed as derogating from the law in force relating to immunities, extends to the whole process of recognising or enforcing a judgment. Now, not surprisingly, I think, neither the judge at first instance nor the full court was very taken by that argument, although they did, to my mind, become significantly sidetracked by arguing at great length about the question of whether enforcement and execution are the same thing or whether they are not the same thing. But they, to some extent, ducked the issue, to my mind, by saying that essentially, if you look at Article 54, and if you look at what the claimants in the Spain case wanted, which was really an order for recognition and enforcement, they said, well, what this proceeding really is a proceeding for recognition of the judgment. It's not a proceeding for enforcement, even though the orders of first instance did actually provide to enforcement. So what they say is that, one, the obligation to recognise an award is unequivocal and unaffected by questions of immunity from execution. So there's no question of immunity when it comes to the recognition of an award. But when it comes to execution, then immunity does become relevant. So Articles 54 and 55 take for granted that there would be state immunity from execution. And then they said that a proceeding which seeks orders to permit or facilitate enforcement, that is, seeking an order for recognition and enforcement, is actually a proceeding which is a species of recognition. So they said what the claimants are really asking for is an order that the judgment be recognised. This does not raise questions of immunity because it is clear that Spain agreed to the ICSID Convention, and the ICSID Convention is clear that the court should recognise an award when it's presented to it, and therefore we don't actually have a problem. So that's the decision in that case, and what it does really, I think, is just defers the whole problem to the execution stage. Of course, what's never been clear in these proceedings is whether, in fact, Spain has any assets in Australia at all. So it's really not clear why they're doing this. Now, there are quite a lot of other cases sort of going on or raging around this issue of sovereign immunity, but I will mention here a 2020 UK case called Micula and Romania. Now, this has an extremely complicated fact situation, which I would be incapable of explaining to you, even if I had the next hour or so. But essentially what it relates to is a dispute between the EU, which is, as it was in the Spain case, contesting the question of external awards where you have agreements or disputes between EU states, which they say should be resolved under EU law, and an attempt to enforce an award. So these people invested in Romania before Romania became part of the EU. They were offered subsidies to do so. When Romania became part of the EU obliged us to pull the subsidies. So they sued Romania, or they got an award against Romania on the basis Romania had failed to give them free and equitable treatment, which I think was undoubtedly true in the circumstances. Promises had been made and then the promises were pulled. So the argument here was whether the UK courts could or should continue a stay of proceedings until the matter was fought out within the EU. And what the lower courts had done was they'd said, well, if we look at the ICSID Convention, what the ICSID Convention says is that when you recognise an award, it should be treated as if it were a judgment of the court. So say in our Spain case, once the federal court has recognised the award, it should be treated as if it were a judgment of the Spanish court. And step 2 of that analysis is that means that in relation to that award, you can treat it as if it were a judgment of the court, which means that you could grant a stay. Because you could stay enforcement of a judgment of your own court, and therefore you can, using your own domestic laws, therefore stay and take other procedural steps in relation to that international award. You're looking puzzled, Luke. Yeah, which is perfectly logical. Where it all falls apart in the Mikula case is stage 3, because what the Supreme Court said was, well, all of that may be true, that you could grant a stay of enforcement in relation to an ICSID award on procedural grounds. But what they wanted to do was to grant a stay until the EU and the CJEU and so on had fought out the question of the Romanian subsidies under EU law. And, said the Supreme Court in a very disapproving sort of way, this was not granted on procedural grounds, but it was a prohibition of enforcement on substantive grounds. And this was, in fact, a no-no, and therefore it could not be done. But nevertheless, I think the case is quite useful for our purposes, because if we go back to our Spain case, it would mean that potentially Spain could, if they could find the appropriate procedural ground, ask the court to grant a stay, because the award should be treated as if it were a judgment of the federal court. Now, I know Chester's going to cut me off at this stage, so I'll just mention some of the other delights which are lying there in wait should you wish to pursue this subject any further. And one of these is one in which Chester himself should actually be involved, or was actually involved, which is Lighthouse Corporation and the Republic of Timor-Leste. There was an ICSID case involving this. It was a fuel supply contract, which essentially got nowhere because there was no jurisdiction. Then it came to the Victorian courts, and ultimately to the Victorian Court of Appeal, in which Timor-Leste was arguing, well, in fact, you can't take this case against us because of the Act of State doctrine. And the Act of State doctrine, of course, essentially says that you can't, in certain circumstances, take actions relating to the acts of foreign states because it would be inappropriate or unsuitable in the circumstances. But since Timor-Leste had actually argued in the ICSID case that it was just a fuel contract and not an investment, they were really not in a good position to argue this, because the Victorian court said, well, you said yourself it's just a fuel contract. It doesn't actually involve any of the circumstances under which the court won't look at an act of state. But I should say that there's a little bit of a disagreement between that and Garuda Indonesia, which is really the case that keeps on giving, because of the question of what the relationship is between act of state and the commercial transactions exception to state immunity. Because there is, of course, a certain amount of overlap in terms of act of state and sovereign immunity. And in Lighthouse, the Victorian court said in a very hearty sort of way that the act of state doctrine cannot negate the Section 11 commercial transactions exception. That is, if the Foreign State Immunities Act says that you don't have immunity because you've been engaged in commercial transactions, you also can't plead active state in those circumstances. And that was actually not so clear from Garuda Indonesia. Anyway, I will stop there. I'll just note that Garuda Indonesia is going to present even more interesting questions because they are still arguing about pecuniary penalties imposed upon them as a consequence of their price fixing cartel. And so who knows, we may see them up before the High Court arguing active state and the commercial exceptions as well. So I'll stop here with the conclusion, really, that I think that we're going to see a lot more of these cases. I don't think the current regime is actually coping with them all that well in terms of how we're going to deal with all of these cases. It's not really, I think, a purely technical question, which is the way we tend to treat sovereign immunity in Australia in terms of law, because there are so many policy issues that underline the reasons for why these cases actually come out and how they're going to be dealt with.
Well, I feel definitely outclassed following two such fantastic presentations. I hope you all can hear me. At least the jackhammering next door seems to have stopped. I also apologize for not being there in person. I actually settled on some real estate yesterday, and so I'm already starting the whole moving extravaganza. So my apologies for not being there in person. Many thanks to Rosemary, to Mary, and of course to Chester as well for allowing me to speak. I will be brief. I know we're a bit behind time, and basically it's never good to be between, you know, the drinks or the ride home on a Friday night. So I'm talking a little bit about my book, which I will show to you, and it's of course mirrored so you can't really read it. Legal Reasoning Across Commercial Disputes, and it basically is comparing judicial and arbitral analyses. And the book is the culmination of a grant-supported project, very, very generously supported by the AAA ICDR Foundation, although they did not involve themselves with the analysis of the information, looking at whether there are any differences between judicial and arbitral reasoning. And the reason I got involved with this particular project is because I've been in the field of international arbitration for years, and there's always been this stigma associated with commercial arbitration, that it is some type of second-class justice. And I believe that a lot of that stigma comes from the either legitimate or, dare I say, illegitimate concerns about other types of arbitration, particularly consumer arbitration in the United States, which is very, very different and has a lot of problems, and the concerns about investment arbitration. As we heard today, there's been quite a backlash in the last few years. And I've been around long enough to remember when it was the new, hot, exciting, good thing. And the backlash against ISDS has really affected international commercial arbitration and to some extent domestic or commercial arbitration. So I wanted to think about why that pervasive misconception was continuing on. And essentially, there's been a lot of empirical research about arbitration in various contexts, but it is focused on things like outcomes, whether outcomes are actually different between different types of arbitration and maybe judicial processes. User satisfaction rates, whether there's an existence of bias based on the certain attributes of the adjudicator. Citation counts to see whether arbitration is as legalistic as judicial decisions. But there's really little about those empirical studies that have to do with the reasoning process per se. And in my mind, I think a lot of this concept of second-class nature of arbitration has to do with this perception that arbitrators do not conduct legal reasoning, that they are simply acting as kind of business experts and acting ex aequo et bono. Or as amiable compositors and just going off of equitable analyses. And my experience as an international arbitrator and advocate in that field suggests that nothing could be farther from the truth. So I set up this study to look at the differences between judicial and arbitral reasoning. I defined legal reasoning relatively broadly because I do think that reasoning is a holistic exercise based again on my experience as an arbitrator and seeing how decisions are made. Also, I was a Supreme Court fellow at the US Supreme Court, and I worked with the Federal Judicial Center, which is the education arm of the federal judiciary. And I realized that there's nothing, that no assistance is given to new judges. They're just thrown out into the deep end. And that's quite typical in many common law jurisdictions. Not so true of civil law jurisdictions. So I wanted to get into, what are people doing when they are conducting legal reasoning? As I was doing this, putting together the basic study, I thought, I'm never going to do this again. And now in retrospect, I will say I'm never going to do this again because statistical studies are a pain in the neck. So I decided to see if I could address several different issues at the same time. So I also looked at and tried to compare reasoning in domestic commercial disputes versus international commercial disputes, because I had this perception that international commercial arbitration was much more sophisticated than domestic commercial arbitration. But I didn't know that for sure since I mostly did international. And then I wanted to compare common law and civil law reasoning because there have been some allegations, both anecdotal by practitioners as well as theoretical by scholars, that the two legal families are converging in some ways. So it was really a tripartite study, 3 basic goals, looking at legal reasoning across the judicial, arbitral, national, international, and common law, civil law divides. So because I had 3 there, I used a 3-pronged methodology as well. I used a survey of judges and arbitrators, a set of semi-structured interviews also of judges and arbitrators, and then a quantitative or coded analysis of judicial decisions and arbitral awards. And let me break those down a little bit more. For the survey, I ended up asking 465 judges and arbitrators from around the world a series of questions. The total number of questions was 73, but not everybody answered everything because of various types of switch coding. And then I ran various statistical analyses on those responses. I conducted 20 semi-structured interviews, and those of course have a preset script that I follow very rigorously so that the same questions are asked in the same order of these different individuals. There were 27 questions, and even though there was a much smaller number than the survey, we were basically hitting the same subjects. And the attempt here was twofold. One is to get to the why of certain answers, because I was allowed to probe certain responses from the interviewees, and also to have the opportunity of checking myself. The survey, once I put it out, I could not alter the questions, and the interviews would give me the opportunity to see if I missed anything. Happily, it turned out that I did not really miss any major portions of their reasoning process, which was a relief, but that was part of the rationale. Also, by having very similar questions asked in the survey and in the interviews, I was able to double check or kind of cross-refer the responses. And one of the ways to find legitimacy in a empirical study is to duplicate, see if the outcome is can be duplicated. And even though these are 2 different mechanisms, I was able to see whether my responses were consistent. And for the most part, they were. And that was very kind of helpful in showing that my analysis was going to be correct. The 3rd prong was this coded analysis of decisions and awards. And again, I ran a statistical survey or a statistical study of the responses I got there. I ended up having 70 commercial awards in the original, and these were all obtained from the United States. They were awards that had been attached to attempts to enforce or confirm an arbitral award, either domestic or international. They were all commercial. My RAs did initially pull some investment awards that were under contract, investment contracts as opposed to BITs. We pulled those out, so they're not part of this study. 36 were international, 34 were domestic. Then we had the judicial decisions, and honestly, those were harder to find than the commercial awards, which was the absolute opposite to what I expected, and I'll explain more why in a minute if I have time. I ended up with 7 US decisions, yes, only 7, and that itself is problematic. 92 from the English Commercial Court, and then 28 from Quebec. Quebec, of course, is a civil law jurisdiction within Canada, but they are English speaking. I decided not to do a multilinguistic study for a variety of reasons. And Quebec was kind of the best stand-in for a civil law jurisdiction. So the short answer is that I found that there were no significant differences in the reasoning style used by judges and arbitrators. And that is what I had anticipated, but I used good social studies approach and used a null hypothesis and tried to disprove that. And this is going to be interesting because the differences that I found, and there were some significant differences in how individual arbitrators and judges did decide things, that suggests that those distinctions are individual and not institutional. It is not related to the roles that they play. And we actually had some people who were both arbitrators and judges, and that helped kind of suss out whether and why any differences arose. This could be quite significant for whether parties choose to go into litigation or arbitration, because of course we know that in arbitration you can to some extent pick your arbitrator. But interestingly, we do not ask the kinds of questions of our arbitrators in interviews or in kind of the networking that you do informally. We don't ask the kind of questions that are going to help us. So perhaps identifying a way to have a questionnaire for how different arbitrators reason through things would be helpful to the parties, because then the practitioners could offer the appropriate information to the arbitrators, cut down the time that you are spending in hearings, have for a better outcome. It would be very helpful, but it does show a potential benefit of arbitration because you cannot pick your judge. The second interest is that there are some differences between domestic and international proceedings, and here I'm mostly focusing on arbitration, partially because it was difficult to pull out the international matters in the judicial side. But for the most part, they did seem relatively consistent, and this was a surprise to me because I did not think that commercial arbitration would be as sophisticated as international commercial arbitration. And partly I think that this is because both groups said that they focus more on the facts than on the law in in commercial disputes. And again, this is not something I had anticipated. Perhaps those of you in the audience did, but it was different for me. And then the last kind of prong of analysis is the common law and civil law. And I found that some differences do exist, others do not, which supports that concept of some convergence, but not absolute convergence between the two different legal families. I have a few more points that I can make. I'll run through them quickly because I know, as I said, we're at the end here. First, I said that I defined legal reasoning quite broadly. I looked at things like the relative importance of different types of legal authorities, whether and to what extent a judge or arbitrator would conduct independent legal research, and how they incorporate legal authorities into their decisions and awards. There's been a lot of, oh, sorry, I have a puppy and she just woke up and she startled me. She's silent as the grave. She sneaks in and she just nudged my elbow to tell me she was here. There have been a number of citation count studies that purport to show the legality or non-legality of arbitration, and how the legal resources are used is an important question that this study gets to. I also looked at factual authorities, what we would call evidence, and this is largely ignored both by arbitral researchers, judicial researchers. Nobody's really looking at how factual authorities are used in legal decision making. And I had a series of questions on those, which I found absolutely fascinating. And it allowed a comparison of data over this legal evidentiary divide. And I think that's one of the most stark kind of outcomes from this particular analysis. Because it was so holistic, I was able to pull out different comparisons that other studies did not. Another one that's kind of one of my little hobby horses is differences over the procedural and substantive divide, which I will not go into. Let's see, I'm trying to whip through these this is the other reason I don't use PowerPoint, so that I can kind of go quickly through things. The methodology was also quite distinct in that I used different types of coding analyses. Instead of looking only at citation counts, as colleagues have done in the past, I used a unique paragraph by paragraph analysis of these coded awards and decisions, which helped show not just how much weight was being given to the legal discussion or the factual discussion, but also what we would call the analytical discussion, the putting of the law together with the facts. And that yielded some very interesting kind of outcomes. And then the last thing is these unexpected elements. The fact that I did not expect to have so many difficulties finding trial level commercial cases. And the fact that so many of these decisions at the trial level are not reported. And this creates a real imbalance between the perception of arbitration and the perception of litigation, because we are seeing, for the most part, appellate decisions, and we're seeing the best of all written opinions from the judges, those that are published. Whereas in arbitration, we're seeing all of them, and we're seeing them again at what would be the equivalent of the trial level. So there's a lot of other unexpected elements that I will not go into, but I know that Jeanne and Luke would love to jump in here. So I'll just conclude here and say, buy the book. It's really thick, and there's a discount code that I sent around, and hopefully you've seen it on the materials in case you want to buy it. But happy to answer other questions about it. Thank you so much.
Thank you, all the speakers and everyone for staying in this room and virtually, if you're listening still. Yeah, so I was going to focus my remarks on Maureen's presentation, but I can't resist saying a few words about Stacie's new book because it sounds terrific. And next time I'm in your neighbourhood, which is not far from mine, I'm going to just grab a copy. But I just thought, well, first of all, just on your outline of the methodology used, which sounds very interesting, it strikes me that you've got quite a small sample of arbitration awards. I think you mentioned around 30 domestic, 30 international. And then the 30 domestic ones, say, presumably in the US, right, you'd expect them to sort of correlate with US and UK court judgments, perhaps because we have this tradition in the common law of appointing ex-judges as arbitrators, right? Whereas in other civil law jurisdictions like Japan, which I'm more familiar with and so on, that's very unusual. You might have more professors appointed as arbitrators, or Germany is another example, right? And then for the remaining international arbitration awards, say 30 odd, presumably they're from many different countries seeking enforcement from around different parts of the world. So like for different countries, and let alone the arbitrators within those awards, right? There's quite a diversity of international arbitrators and their backgrounds. And then you're trying to correlate that against the judgments, so it's primarily from the US, UK, and Quebec. So, you know, I don't know how far you can generalize. I think you've got a methodology established then for lots of PhD students and others to do like a much bigger study, like trying to be a bit more granular. And maybe they'll end up with some different conclusions. But let's assume, this is my second last comment, this is all off the top of my head, but it also struck me as, okay, let's assume that we do a bigger study and we find that, yes, your results still hold. The arbitrators are, you know, adopt the same types of legal reasoning as the judges. Then the question is, okay, so why? And what are the implications of that? So one reason I could think of why is maybe arbitrators in the whole field is trying to gain legitimacy. Right? And so that's Desilets and Garth talking about the sociology of arbitrators and how, particularly international arbitration, you know, it's a new field at the time, 30 years ago and so on. So to build it up, you try to sort of mimic judges. And we see this in investment arbitration too, right now. So, you know, attempts to make ad hoc arbitration more institutionalized, more like a international court, for example, or even have an international court as an alternative to ad hoc arbitration. But that's one possibility. Another possibility is maybe it's the lawyers and to some degree the arbitrators just wanting to have more hourly rate fees paid, right? So, you know, and make it more formalized and complicated and so on to make more money. So it's a very different sort of reason why we might see this trend. And then if you follow that line, particularly the latter, more cynical one, which I've come around to increasingly over the years, I must say, maybe it's that maybe that's not a good thing, and so what are the implications? Well, maybe this isn't a good thing. Whereas you were trying to say, Stacie, as I understood it, that, you know, it's a bad thing if we have this idea that arbitration is not as legalistic, formalistic as courts litigation, but maybe that's not necessarily a good normative outcome. Anyway, we can have a discussion later about that, but that's just some immediate reactions. The other quick reaction was to Maureen's very helpful outline of the review of the Australian BIT program, or what's left of it, because as you say, we've got rid of some over the years, and this is well overdue, I think. A number of people have been saying, not just myself, but others in parliamentary treaty ratification hearings, which is forward-looking, adopting new treaties. Don't forget about those old treaties. In some ways, that's more important because, as you say, Maureen, they've got these sort of broadly worded provisions from the early days of treaty drafting in this field. And now we have these more sophisticated forms of drafting, influenced actually led quite a lot by the US, which had some early and lots of cases, and then sort of redrafted their model BITs and so on to, and influenced a lot of countries, including Australia and Japan and others in the Asia Pacific region, to have more sophisticated drafting. So this is a good initiative, and also it's good in the sense that we see, as not just quite a bit of interest, but quite detailed submissions, particularly from a range of academics, experts in the field, whereas you don't get as many called to give evidence and influencing, I think, the discussion in the treaty by treaty ratification parliamentary hearing. So that's encouraging as well. The other point I was going to make is, though, really what's the format that's going to come out of this? So you mentioned, for example, that there are Australia is going to have sort of negotiating mandates, as will presumably counterparties and so on. And I wonder, if they're going to be made public and whether there'll be opportunity to have an input in that and so on. But also, like, what is going to be the template for Australia to move forward? You mentioned something like the Australia-Uruguay revised BIT, which in turn was heavily influenced by the CPTPP, US-style drafting, and so on. But could we go a step further, as people have said in the past, and have at least model provisions, even option A, maybe preferred, and then option B, C even, to discuss in public before you approach the counterparty state with those options, or even a model BIT, as many countries have. I understand that in a more politicized world, and that if you don't get your option A, the government and even the officials might get sort of scolded by the public for not having achieved option A of every single thing in the negotiation with the treaty. But hopefully, more realistic heads will prevail and say, well, you tried, and there was some give and take, and you ended up with something that was overall pretty balanced and in the national interest of both countries. That was my main point. I also wanted to conclude by saying, when you come up with the negotiating template, I'm not sure how detailed it'll be and to what extent it'll be made public and discussed further, as opposed to just, when the treaty is eventually concluded, us academics trying to reverse engineer what you've achieved, try and work out what your template, your negotiating mandate and template was. I hope you can add some innovations. And we were just talking in the corridor before about the new Indonesia-Australia FTA, which got rid of the poorly worded BIT that didn't have clear wording on the consent to ICSID arbitration. But the new FTA has clear consent, but it has this very unusual feature of mandatory mediation before arbitration, which my PhD student, Anna Ubalava, has been researching for 4 years and done a big empirical study, published part of it last year in the Journal of World Investment and Trade, saying, there's a lot of settlements that go on across all types of investor-state disputes, and this can save a huge amount of cost and delay as arbitration costs keep going up in commercial and investor-state arbitration. So that's a very interesting innovation in the Australia-Indonesia FTA, and you were telling me you were involved in that negotiation. So well done, Maureen and team. Take credit for that one, even though I've written a blog posting suggesting it probably came from the Indonesian side for various reasons, but you couldn't possibly comment. But at least Australia agreed, if that was the case. And, you know, why not take credit for it? And even though it's only in one treaty for Australia, put that in your template. Make it an, you know, option A. And we'll put it out there for discussion in the public and see if people agree with me, and especially experts like Anna. So thank you.
Hello, everyone. I will try to be very brief because I understand I'm the only barrier between you and the dinner. Okay, so I just want to briefly respond to Maureen's argument. I really love it, the typical safeguard provisions. And the first one on Maureen's list is government rights to regulate, and the last one on Maureen's list is improve transparency. And I actually see a tension. One hand is government right to regulate. In terms of, I limit my very brief response in terms of data of national security interest and personal data. So the government right to regulate this kind of data mainly is security. And then we have at the end of the list is transparency. And I think Chester and Maureen, they all agree transparency is the key issue in the ancestral working group regarding the legitimacy of ISDS. So here we see the security and transparency. So let's first look at the data of national security interest. So actually I do a very preliminary research regarding Australian investment treaties, the provisions for disclosure and confidential of information. You can find such provisions either in the investment chapter, if it's an FTA, or in the general exception chapters. So I found that 10 free trade agreement, for example, Australian-Korea free trade agreement, allow a member state not to provide the confidential information, the disclosure of which will impede the law enforcement or the public interest according to that state's law. I have the private international law background, so I always pay attention to which law should be applied. So in this provision, it said a member state's law. So it means the member state, it can be the investment home state or investment host state. And then in this 10 free trade agreement, they also provide the state receiving information must not disclose or use received information for any purpose other than that for which the information was requested, except when the law of the receiving state require disclosure. So what does it mean? It means that Australia's data that should be protected according to Australian law may still be disclosed by a receiving state. So you see, when the law of the receiving state require disclosure. The second group, which conclude 5 free trade agreements, typical example is Australian-China free trade agreement. They do not require an investment host state. So here, the 5 free trade agreement, they focus on the law of the investment host state to disclose protected information. So if Australia is not an investment host state, it may have to disclose data that should be otherwise protected under its law in investment dispute settlement. And then the third group included 1 free trade agreement on all BIT except the Australian Uruguay BIT, which Maureen already covered in her presentation. They have no information disclosure or confidential provision because Australia last year ratified Mauritius Convention. A Mauritius Convention applied to all BITs, which concluded before 2014. So if you look at the Mauritius Convention, Article 7.3 of Mauritius Convention provide that who has the final decision power regarding what information should be kept confidential? It's the arbitration tribunal. So here we go back to Maureen's argument that the government right to regulate. So it means that it is not really 100% certain for Australia as a host state or as a home state that the information of significant national security interests will be protected because it will be subject to the tribunal to decide. And then let's look at the personal information. So for personal information, we can look at our Privacy Act. Our Privacy Act defines personal information very broadly, but Mauritius Convention incorporates the ancestral rules on transparency. Article 7 of Mauritius, Article 7 of ancestral rules provide an exception not to be transparent, and personal information protection arguably should be included in the exception, not to be transparent for whatever reason. But the ancestral rules actually focus on the protection of commercial information. Because if you look at Article 7.2 of the ancestral rules, so it regulates the confidential business information. But the personal information, so for example, the genders, for example, your email address. Actually, Chester nicely, when I do the research, and Chester nicely pointed out, in Philip Morris case, an Australian government successfully redacted the name of the government officials who made the decision regarding the tobacco case. But not every case that Australian government or other government will be able to do that. You may have to litigate very hard in the arbitration process in order to convince the tribunal. So what will be the consequence? There are two consequences, at least I can estimate. The first one is regarding what information should be protected, what information should be considered national security interest, what kind of personal information should be protected and how to protect it, which will make the procedure issue very long, right? The parties will fight very hard on those procedure issues. So it may make the proceeding more expensive, which is good for lawyers, okay, but it may not be good for some small countries, or may deter some investors, small and medium-sized enterprise. They have no money to litigate regarding the procedure issue, which information should be protected. And the second, I think, is more detrimental is what kind of impacts, that which law should be applied to information protection, how to imply, how that will impact on the transparency, which we all agree is fundamentally important. So finally, I just want to use a statistic and let you know how important it is. So according to the IBM Security and the Polymer Institute, the average total cost of data breach in Australia in 2020 was Australian dollar 2.78 million. So it is realistic, it is an issue. Okay, thank you.
Well, thank you very much to our three speakers and to our two commentators. We've got just a very short amount of time left for questions, and I do want to allow our three speakers to have a very brief right of reply to the commentators. But are there any questions from the floor? There was one question that came through on the chat, which I'll put to Maureen, and maybe she can, or Mary has a question, and I'll ask this question to Maureen, that if she can address it in her sort of in her final words. But Mary, please.
I have a very short question, and this comes from the fact that we were trying to find decisions to summarise for 2020. It seems to me, both from the presentation and our research, that remarkably little was done in 2020 in this area. And I'm just wondering if anyone can explain why that might be, apart from COVID-19. I mean, that's why we all got shut down. But in a lot of other areas, people seem to have pushed on with virtual meetings and so on. Have we missed something?
There were. Well, I can offer a brief response from the lectern, which is that the work of UNCITRAL Working Group 3 did progress in 2020. This is the work which is happening on the reform of ISS, which Stephanie Ireno mentioned in her presentation earlier today. There was an in-person meeting that took place in Vienna in the third week of January I had the privilege of attending with Maureen and another DFAT colleague. I think that was the week that the world heard about COVID-19 for the first time. And there was to be another meeting to take place in April or May. That had to be cancelled, as everything was from March, April, May. And then there was a further meeting of UNSTRAL Working Group 3 that took place in October, and that, or early November, that took place remotely. And there's been another meeting just about 3 weeks ago that took place remotely. And I again attended with DFAT. That was, as Stephanie mentioned earlier today, negotiations began at 9 p.m. at night and went through till 3 o'clock in the morning if you were sitting in Canberra. But that work has continued. A lot of ICSID's work on reviewing the ICSID rules has continued as well, albeit in this sort of virtual sense. And investment arbitration hearings have continued via Zoom and WebEx and all sorts of other platforms. So the work has gone on, but perhaps fewer issues affecting Australia that have taken place in the last 12 months directly.
No, I would say actually that with the sovereign immunity stuff that we've had quite a lot of important judgments. I didn't get through to a number of them. I mean, these are really big cases. You wouldn't expect them to come up all the time, but we've had a couple of major cases in Australia going up to the High Court actually in the last sort of 5 to 10 years. Plus we've had a lot in the UK, as one would expect, and the US courts are extremely active in this particular area. So one of the reasons I picked it, in fact, is because there are so many cases coming up and they're being heavily disputed, and I would expect that there are going to be more of them.
Okay, I might just go through our speakers, and beginning with Maureen and Vivienne and Luke, and just if you can keep your sort of just a 1 minute type reaction. And I think the one suggestion that came through on the chat, or the question, as whether the issue which Professor Barth has talked about, the question of state immunity and whether there should be any express waivers of immunity drafted into Australia's future bilateral investment treaties, whether that should be made express or left is at the moment, and it's maybe just really some food for thought rather than for you to give an immediate reaction. But anyway, over to you, Maureen, and please respond to anything that you've heard that you'd like to respond to.
Okay, thanks so much, Chester. I've written down a couple of questions. So thanks very much, Luke, for your comments. To answer your questions directly, will there be a mandate made public? The normal practice is for negotiating mandates not to be made public. That is the normal process that will no doubt apply here. The next question you asked, will there be a model bit? Well, I'm actually not at liberty to say yes or no on that, but what I can say is whether a country has a model or whether a country has taking an approach of, one step down of having a preferred approach, then ultimately, at the end of the day, the renegotiations involve two states, and so it'll be quite common for the model to be the ultimate product at the end. In terms of you wanting to gain some deeper insight into where we're coming from, what I could point you to is the practice of Australia at the moment. Certainly some of the cutting edge in this area is in the ICSID and the CPTPP. And certainly we'll be looking very closely at particularly the academic submissions that were diving into, the specifics and the details of some particular provisions. So I'm hoping that I've addressed your 2 points. Thank you very much for your very good analysis in relation to the tension that necessarily exists between the government's right to regulate and, on the other hand, opening up ISDS and making it more transparent. What I would just very quickly say in terms of government right to regulate, there hasn't been enough of that included in our bits hasn't been expressly made clear. So the type of thing that we'd be looking for, again, would be the type of things that we've got in our current practice, like having footnotes in our MFN and NT provisions referring to like circumstances, carve-outs. We had a public health carve-out in IASEPA. Obviously, as a result of the pandemic, that has become particularly a significant issue. General exceptions. We don't have general exceptions in our bits. And I would just, without having had the opportunity to think through your points, I would say that generally there is always, in terms of transparency, an exception for transparency for confidential information. So, you know, there is a balancing that goes on, but it's very good to have those points about that tension of government right to regulate and transparency really highlighted. The point that you just raised, or was raised, whether it would be appropriate to have a waiver in our bits, well, that really, I think, gets to one case that came up last year in October, which was the tantalum case, and that involved consent. We need potentially to resolve those consent issues, and I think that goes some way to dealing with waiver, because if you've got a really very clear consent there, then it's very difficult. I don't think it's possible to even argue state immunity. But yeah, there probably does need to be some clarity in terms of consent.
Okay, thank you, Vivienne.
I would look at that a bit the other way. I was thinking in terms of the general problems, in terms of state debt, and in terms of the size of some of these wards. I was playing around with the idea that just as in a commercial contract, you can limit your liability. Governments, particularly smaller governments, should probably be looking at putting a cap on liability when it comes to contracts with investors, and potentially they could look at doing something similar in terms of the ISDS provision, to limit how much they are actually prepared to pay out in terms of a failed investment project, rather than getting some of these. I mean, most awards are fairly reasonable, but then you get these outrageous ones which then start discrediting the rest of them. But certainly I think that the question of what assets you can execute your debt over needs to be looked at a good deal more carefully. If you consider, for example, Firebird and Nauru, what the investors there who Revolta Fund were after were essentially the state funds of Nauru, which were being used for a whole lot of absolutely vital functions for the citizens of Nauru. And Nauru had to prove in the case of each account exactly what it was used for at the High Court, which was really a very significant expense, and a very difficult thing to do. So I think that's why I think that you need a sort of overall examination of the entire area, not piece by piece.
Okay, thank you. And Stacie, do you have any reaction to perhaps Luke's comments?
Absolutely, because Luke has made some very good comments that I had anticipated and just didn't have a chance to get to. The first and the most important one is his comment that there might have been a US bias in the surveys or the interviews. The interviews less so, because I did make an effort to be very global, because I don't want to say cherry pick, but I could consciously look for diversity. Within the survey, there was a strong US bias because of how it was circulated and the fact that so many places around the world refused to help me, which annoyed me no end, because I contacted hundreds of judicial and arbitral organizations around the world and did not get that kind of support. And that will be the subject of an article at some point. So I do take that into account, or at least mention it in the book, because I think it is something we need to take into account. That, and the fact that even because everything was in English, even those civil law lawyers who were speaking about something from a civil law perspective, they've already been, I don't want to say infected by common law thinking, but if they're internationalists, they are used to a diversity of ways of looking at legal analysis. So that is something that is important, and I would love to see this research duplicated in other languages, as has happened with some of Tony Cole's work at the EU level, but I just didn't have the budget to have all the translations. The other point that he made is one of his kind of speculative hypotheticals about Are arbitrators just trying to increase their fees and make things more legalistic, or is it a question of legitimacy? One of the pieces I wrote a number of years ago looked at that precise issue, the increasing legalism and formalism in international arbitration. And my conclusion was not that we as advocates and arbitrators were trying to drive the matters to a more legalistic approach, but the nature of the disputes have changed over the last 40 years. I've been doing this for 25 years now, and even within my career, I've seen changes from relatively simple bilateral single contract matters to multi-party, multi-contract matters, which require a lot more analysis, a lot more question of what law is controlling, which contract is going to control this particular issue, a lot more different fact elements, and that kind of complexity requires a more complex analysis at the legal reasoning level. So I don't think it's just monetary concerns by the people whose wallets are getting lined. I do think that the nature of many disputes is in fact changing. And that's it.
Okay, well, thank you very much, everybody. We've run out of time. In fact, we're 5 minutes over time, but will you all please join me in thanking our speakers and commentators. Thank you.